All right, today we're going over liquidated damages and deposit disputes. This is part 2. When a buyer breaches a purchase agreement, a seller may be entitled to damages. How much will be typically depend on whether the liquidated damages provision was initialed and thereby made part of the contract. If it was, then the seller will likely be entitled to the amount of the deposit. If not, then the seller will have to prove their losses. Training session addresses liquidated damages clauses, which award damages only to a seller in the event of a buyer's breach of a real property purchase contract. This is a type used in the car purchase agreements and is the most common type of liquidated damages clause used in the real estate industry. Liquidated damages clauses awarding damages to a buyer in the event of a seller's breach and leases or other types of contracts may be subject to different rules and generally should be used actually should not be used without first consulting with an attorney. Challenging the liquidated damages provision. If the liquidated damages actually paid is $5,000, what happens if the seller incurs an actual loss that is much greater than $5,000? The seller will likely be unable to claim more than $5,000. That was the purpose of the liquidated damages provision, to agree in advance as to what the buyer will pay in damages in the event of a breach. Most judges will be very reluctant to disregard this provision. Under what circumstances will a judge disregard the liquidated damages provision and permit the seller to attempt to prove actual loss? Only in rare circumstances. In general, if the property is a residential dwelling of no more than 4 units and the buyer will take occupancy, the law does not permit the seller to establish the unreasonableness of the liquidated damages as too low. Perhaps if the buyer placed no money at all into escrow, then a judge might ignore the literal language of the law and disregard the liquidated damages provision, thereby permitting the seller to prove actual damages. How may a buyer challenge a liquidated damages provision? Where the property contains no more than 4 dwelling units and the buyer intends to occupy it, then the buyer may challenge the liquidated damages provision establishing that the amount actually paid is unreasonable. In general, the reasonableness of the amount actually paid as liquidated damages is determined by taking into account both the circumstances existing at the time of the contract was made and price and other terms of any subsequent sale or contract to sell the same property if the sale or contract is made within 6 months of the buyer's default. The most common scenario where a buyer may have a greater likelihood of success is a very hot market where a seller resells a property quickly and for more money. In such a scenario, it could be argued that the buyer's breach actually benefited the seller, and a judge may be unwilling to give the seller both the benefit of the increased price received from the sale of the home to the new buyer and the full deposit of which the buyer whose breach actually benefited the seller. It's clear that a residential buyer will have an easier time of challenging the liquidated damage provision than a seller. However, most of the time, judges will be reluctant to disregard an agreed upon liquidated damages provision, even where it is the buyer that is challenging it. In property sales other than residential 1 to 4 units where the buyer is to take occupancy, under what circumstances may a judge disregard the liquidated damage provision? For other types of properties, a liquidated damages provision is valid unless the party seeking to invalidate the provision establishes that the provision was unreasonable under the circumstances existing at the time of the contract was entered into. This would be the same rule for both a buyer and seller. Are there any limits on how much money a seller can safely collect from a buyer as liquidated damages? To be deemed valid, a liquidated damages clause in a real property purchase contract liquidated damages to a seller should reflect a reasonable estimate of the actual loss that the seller would suffer in the event of a buyer's breach. While the reasonableness of a liquidated damages clause depends on many factors, The basic objective of the law is that sellers not use liquidated damages clauses to punish buyers unfairly or to make a large profit over and above their actual financial injury. In addition, more specific rule applies if the real property being sold is a dwelling containing not more than 4 residential units, one of which buyer intends to occupy as a residence as at the time of purchase contract is made. In these types of transactions, a liquidated damages clause identifying all or part of a buyer's deposit as liquidated damages will be presumed reasonable if the amount actually paid pursuant to the clause does not exceed more than 3% of the property's selling price. A party challenging the validity of such a clause, typically the buyer, would have the burden of proving that the amount identified is unreasonable. If the amount actually paid exceeds 3% of the selling price, the liquidated damages clause is presumed to be unreasonable, and the party seeking the damages, typically the seller, might have to prove that the amount identified is reasonable. Remember, the car purchase agreements do not permit a liquidated damages amount greater than 3% on owner-occupied residential 1 to 4 units. For sales of subdivision interests regulated by California's Subdivided Lands Act, the law specifically limits the liquidated damages a subdivider can collect from a defaulting buyer to the amount of the purchase money advanced by the buyer toward the purchase of the property. Does all liquidated damages clause automatically entitle the seller to the buyer's deposit if a transaction does not close? A liquidated damages clause only determines the amount of money a seller can recover from a buyer, and then only if the seller can prove that the buyer breached the contract. A buyer may fail to close a transaction for a variety of acceptable reasons, such as where the buyer's obligation to purchase was contingent on the buyer obtaining financing and the buyer could not reasonably obtain financing. To recover liquidated damages, the seller generally must prove in court or arbitration that the buyer's failure to close a transaction was a breach. A limited exception exists for certain sales of subdivision interests regulated by California's Subdivided Lands Act. A subdivider's contract may include a procedure where an escrow holder is authorized to release a buyer's deposit to the subdivider pursuant to a liquidated damages clause if the subdivider provides a specified notice to the escrow holder and the buyer declaring the buyer to be in default, and the buyer does not object to subdivider's notice. Non-refundable deposits. Is a non-refundable deposit clause the same as a liquidated damages clause? No, a non-refundable deposit clause typically provides that the buyer must forfeit his or her deposit to the seller even if the buyer has a valid reason for not closing the transaction. By comparison, a liquidated damages clause entitles a seller to the buyer's deposit only if the buyer breaches the contract. It can be difficult to draft an enforceable, non-refundable deposit clause. Only an attorney should attempt this. And the parties agree in advance that the buyer will pay a non-refundable deposit in the event of a breach. Most likely, no. The law does not permit contracts to impose penalties or forfeitures, including a non-refundable deposit for breach absent gross negligence, willful, or fraudulent breach. In general, judges are reluctant to enforce penalty or forfeiture clauses where they bear no realistic relationship to the actual damages incurred. Courts have found that any provision in a contract by which money or property would be forfeited without any regard to the actual damage suffered would be an unenforceable penalty. Additionally, the RPA's language does not permit such clauses. Under paragraph 21A of the RPA, any added clause specifically or specifying a remedy for a buyer breach, such as a non-refundable deposit or a forfeiture of a deposit, will be invalid if the added clause does not independently comply with Civil Code's liquidated damages rules. So you'll see 21A of the RPA, it says any clause added by the parties specifying a remedy, such as a release or forfeiture of deposit or making a deposit non-refundable for failure of buyer to complete the purchase in violation of this agreement shall be deemed invalid unless the clause independently satisfies the statutory liquidated damages requirements set forth in the Civil Code. Can a seller ask for the deposit to be released before close as a condition of accepting an extension? Yes. The most common circumstance in which a deposit is released is pursuant to a negotiation for an extension of escrow. At that time, sellers who want the buyer's deposit released in the event of default may offer an extension. At the same time, it is recommended that the buyer be required to remove all contingencies. The deposit release should be in the amount that was in fact placed into escrow pursuant to the purchase agreement and should be no more than 3%. However, releasing a buyer's deposit to the seller is not the same as allowing the seller to keep the deposit. Do not provide assurances that the seller will retain the deposit under all circumstances, even if released. It still may be possible for the buyer to attempt to get the deposit back, where the seller breaches contract, where the amount is excessive in relation to the amount of the seller's actual loss, where the seller resells a property and thus reduces their loss. So a release of the deposit to the seller is nothing more than that. It does not guarantee that the seller will in fact be able to retain that deposit in all circumstances. Does liquidated damages clause have to be in any special format? To be deemed valid, a liquidated damages clause in real property purchase contract liquidating damages the seller should conform to the following formatting requirements. If the contract is pre-printed, the clause must be in at least 10-point bold type or contrasting red print in at least 8-point bold type. The clause must be separately signed by each party to the contract. All liquidated damages clauses in CAR's purchase agreements conform to all applicable formatting requirements. Why does a contract state that the amount of the liquidated damages is the deposit actually paid? For residential 1 to 4 unit sales in which the buyer will take occupancy, Civil Code Section 1675 only permits a liquidated damage to the extent that it was actually paid. So the contract is merely reflecting the law. Disputes. If a buyer and seller disagree as to whether the buyer breached a contract, can the seller refuse to release the buyer's funds being held in escrow? Yes, generally a prudent seller will instruct an escrow holder not to release escrowed funds to a buyer only if he or she has a good faith belief that the buyer breached the contract. Without such good faith belief, the seller runs the risk that the buyer will institute a lawsuit or arbitration, not just to recover the escrowed funds, but also to recover penalties or damages from the seller. If the subject property is real property containing 1 to 4 residential units that the buyer intended to occupy as their residence at the time escrow was created, a more specific rule applies. This rule provides that unless the seller is withholding the buyer's funds pursuant to a good faith dispute with the buyer, the seller's failure to authorize the release of the funds within 30 days following a written demand from the buyer may subject the seller to a penalty equal to 3 times the amount of the undisputed funds, but not less than 100 nor more than 1,000, in addition to reasonable attorney's fees. A good faith dispute is defined, in part, as a reasonable belief of one's legal entitlement to withhold the escrow's funds. The property is part of a subdivision regulated by California's Subdivided Lands Act, and the escrow does not close on or before the mutually agreed closing date. Any portion of the buyer's deposit not being claimed as liquidated damages by the subdivider must be returned to the buyer within 15 days after the agreed closing date. This obligation must be stated specifically in the subdivider's contract. The buyer and seller disagree as to whether the buyer breached a contract. Can an escrow holder honor a buyer's request to release his or her funds? Once a buyer and seller have properly executed escrow instructions to an escrow holder, the escrow holder generally will not release funds to a buyer over a seller's objection unless so ordered pursuant to court order after litigation or an arbitration award after arbitration proceedings. The RPA has specific provision addressing this. Paragraph 14H states, release of funds will require mutual signed release instructions from the parties, judicial decision or arbitration award. But there's one exception. Is there a specific provision in the RPA that would authorize release of a buyer's deposit without litigation or arbitration proceedings or mutual signed instructions? So this would be the exception. The RPA has a special procedure for doing just this. Under 14H, a seller or buyer may make a written demand to the escrow for the deposit using CAR form BDRD or SDRD, depending if you're the buyer or the seller, demand for release of deposit. The escrow is then to deliver notice of the demand to the other party. If within 10 days after the notice, the other party does not object to the demand, the escrow is required to disperse the deposit. Here we have section H. And you will see in this section of the RPA, it specifically states if the buyer and seller give written notice of cancellation pursuant to rights duly exercised under the terms of the agreement, the parties agree to sign mutual instructions to cancel the sale and escrow and release deposits, if any, to the party entitled to the funds, less fees and costs incurred by that party. Fees and costs may be payable to service providers and vendors for services and products provided during escrow. Except as specified below, release of funds will require mutual signed release instructions from the parties, judicial decision, or arbitration award. If either party fails to execute mutual instructions to cancel escrow, one party may make a written demand to escrow holder for the deposit, CAR form BDRD or SDRD. Escrow holder, upon receipt, shall promptly deliver notice of the demand to the other party. If within 10 days after escrow holder's notice, the party does not object to the demand, escrow holder shall disperse the deposit to the party making the demand. If escrow holder complies with the preceding process, each party shall be deemed to have released escrow holder from any and all claims or liability related to the dispersal of deposit. Escrow holder, at its discretion, may nonetheless require mutual cancellation instructions. A party may be subject to civil penalty up to $1,000 for refusal to sign cancellation instructions if no good faith dispute exists as to who is entitled to the deposited funds. So this is a pretty important paragraph regarding cancellations in the RPA. Despite the procedure from the previous slide, can the escrow holder still require mutual signed instructions, judicial decision, or arbitration award to release the deposit? And this is going to be up to the escrow company's policy. We did read in section H about this a little bit. Even though RPACA provides for a procedure to release the deposit absent litigation, arbitration, or mutual signed instruction, escrows will sometimes refuse to abide by the above procedure. And again, this is just going to, we have to rely on their policy at that time. If the escrow follows the procedure as stated in the prior slides to release a deposit, what is their liability? The RPA states that if the escrow releases the deposit by following the above procedures, then the buyer and seller are deemed to have released the escrow from any and all claims or liability related to the dispersal of the deposit. What if the escrow holder refuses to release the deposit? Then the seller or buyer will have to either litigate or arbitrate to get the deposit released. The buyer or seller won't release the deposit. Is there a sample letter that demands its release? Yes, there are sample letters for both buyer and seller. For buyers, use sample letter demand for deposit for contingency cancellation, letter B, D, D. For sellers, use the sample letter demand for deposit buyer failure to close, letter S, D, D. Both letters demand the release of the deposit, provided a deadline, and explain that a $1,000 penalty may be awarded in addition to the deposit. Both letters additionally fulfill small claims court requirement that a demand be made for the amount in dispute before filing the complaint. The sample letters can be found in zip forms. Under Forms, go to Select Library, drop-down menu, and choose CAR sample letters. All of the letters can then be accessed. Does a seller or buyer have to always mediate, or when the parties agree to arbitrate a dispute over the deposit? The RPA excludes the requirement for both mediation and arbitration where the seller or buyer brings a matter within the jurisdiction of small claims court. I would like to provide my buyer or seller with information on how to argue their case in small claims court. Does CAR have any information on this? CAR has produced the Small Claims Court Assistance Manual for Realtors and their clients. This is the URL that you can go to at car.org. Purpose of this manual is to help realtors and their clients prepare for and present a case in small claims court. It is not a guarantee that you or your client will be successful in bringing or defending a case, but rather a source of pertinent information that should enable the user to make a more knowledgeable and effective presentation. The buyer and seller agree to liquidated damages clause. Are the seller's remedies limited to pursuing liquidated damages, or could the seller pursue other legal remedies, such as specific performance? Monetary damages represent only one type of legal remedy available to a seller. There are other types of legal remedies that a seller can pursue when a buyer breaches a contract, including specific performance, a type of legal action to compel a party to a contract to complete his or her performance under the contract. Typically, a liquidated damages clause only limits the amount of monetary damages a seller can collect as compensation for a buyer's breach of contract. It does not by itself prevent the seller from pursuing an action for specific performance. For sales of subdivision interests regulated by California's Subdivided Lands Act, the California Department of Real Estate publishes a sample liquidated damages clause, which includes language limiting the subdivider's remedies to liquidated damages. Because the DRE enforces Subdivided Lands Act, the provisions of its sample liquidated damages clause may provide subdividers with guidance in drafting enforceable liquidated damages clauses. The previous question suggests that sellers can often choose from amongst various legal remedies when a buyer defaults. Which is the best legal remedy? Choosing an appropriate legal remedy usually depends on many different factors, including the extent of one's injury, the complexity of pursuing a particular remedy, and potential legal costs. For example, an action for specific performance to compel a buyer to complete his or her contractual obligations is generally much more complex than an action to recover liquidated damages, may be more difficult to win, and may be more costly than an action to recover liquidated damages. A seller who is interested in exploring the benefits and detriments associated with different legal remedies generally should consult an attorney. Also, specific performance against a buyer in a typical residential transaction is very hard to obtain and often not worth the legal cost, since in most cases buyers need loans to purchase the property. For example, if the seller is successful in making the case for a buyer to specifically perform, if the buyer cannot obtain a loan, the buyer still would not be able to purchase the home. If the buyer makes more than one deposit pursuant to a purchase contract, will all liquidated damages clause entitle a seller to all the buyer's deposit if the buyer defaults. Not necessarily. If the real property being sold is a dwelling containing not more than 4 residential units, one of which the buyer intends to occupy as a residence at the time of purchase, contract is made, each payment that is to be part of the liquidated damages to the seller must be supported by a separately signed or initialed, properly formatted liquidated damages clause. In addition, if the total of all such deposit exceeds 3% of the purchase price, as discussed in question 11, the seller could be limited to that 3% even if more is deposited. A CAR form receipt for increased deposit, liquidated damages, which is CAR form RID, should be signed at the time of an additional deposit is made into escrow in order to make any additional payments part of the liquidated damages. Thanks for viewing. We have more training videos available in the Rice Realty office in the training section. If you missed part 1, be sure to check it out. It is posted up in the back office.